A stunning development in the Mike Flynn case. The Justice Department, as we've talked about before, had announced that they were dropping the charges against General Flynn. But a federal judge that now has stepped in and appointed a retired judge to argue against the dismissal. And General Flynn may be charged with perjury for lying about him pleading guilty. This is crazy. Alan Dershowitz in the Wall Street Journal wrote, judges are not umpires, not ringmasters. He says the ruling is, quote, unconstitutional power grab. Joining us to break this all down is a member of President Trump's legal team, Jay Sekulow. Jay, welcome.
Hey, Sean, good to be with you.
All right. Admittedly, I'm not a lawyer. I've learned everything I know from watching television. But so here's what I don't get. Flynn pleads guilty through his own admission and others because they were bleeding the guy dry financially. They pressured his son. They threatened him with a longer sentence, and he said, fine, I'll plead guilty. So he pleads guilty. More information comes out that shows that he probably wasn't guilty. People set him up, et cetera, et cetera. He then makes a plea to the court that says, I want to withdraw my guilty plea because of all this information that's come out. Now the court's saying, well, I know the Department of Justice is going to do this, but now we're going to charge you with perjury for lying to us that you were guilty. Is that, I mean, am I reading this wrong?
No, I mean, you are reading it correctly. So what happened was...
Go to law school.
Yeah, you can go. Or you don't even have to. Maybe just practice law. So here's what happened. This is the kind of the irony of the whole thing, is that the prosecutors, when the Attorney General appointed the U.S. Attorney to evaluate the entire Flynn matter, so he took a fresh look at the entire Flynn case. He found in the course of doing this evidence, documents that are called exculpatory, meaning it provides evidence that the person being here, General Flynn, was not guilty. That exculpatory evidence, including the fact that the FBI had closed its investigation of General Flynn in the field office, saying there was no violations of law, was never turned over to the president's, to the General Flynn's lawyer. Now, here's what the irony is. I mean, of all the ironies. So then General Flynn makes a motion to withdraw his plea.
Right.
Pretty common, happens in criminal cases from time to time. The Department of Justice says, yes, we agree he should be able to withdraw the plea because of this newly discovered evidence and some issues that took place during the course of the prosecution. No prosecution should go forward. The order should have been signed by Judge Sullivan. But what does he do instead? He appoints a retired judge who's as a, quote, friend of the court, amicus curiae, but really is like a special prosecutor. I mean, here we go again, because they're trying to now get General Flynn that he made a false statement in his plea because he said he did it when he didn't do it.
Right.
So
they jammed him. They jammed him into pleading guilty, saying, this is what we're going to do to you and your family if you don't plead guilty. He says, fine, I'll plead guilty. Then he finds out what really happened and says, well, now that I can definitely exonerate myself, I'm going to withdraw my guilty plea. And they said, yeah, but then you lied to us by pleading guilty that we made you plead guilty.
Court, but it's worse than that, because the court actually, it's kind of heads I win, tails you lose. There's no way in which a prosecution would be made by the Department of Justice against General Flynn after they came in and said, hey, this shouldn't have happened in the first place. The basis upon which the interviews took place should have never happened.
Right. So how odd is it? I've never heard, and again, I'm not a lawyer, of a judge saying, my job is to rule on this, but instead of ruling on it, I'm going to tell a retired judge to give me evidence on how to rule on it. What? I don't get that.
Well, 27 times Judge Flood said, and this is, here's the irony of what the judge did here. This judge said 27 times no outside groups filing briefs on behalf or against General Flynn. I'm not going to allow it. Not going to have it happen. And then what happens? He then appoints his own friend of the court to do exactly what he said he would not be appropriate in a criminal case, and says he has the inherent power to do it as a district court judge, which I don't believe he does.
I don't get it. I mean, like I said, I'm not an attorney, but I don't understand what the role of the judge is to preside. And he's saying, you know what? I don't want to be the bad guy here, so I'm going to appoint one of my buddies to be the bad guy, and then I get to concur with him. But Jay, knowing what you know now, okay, all the Flynn stuff comes out, everything that we've seen with the 302s, how much different would the Mueller case have been, or not at all, had we known then what we know now?
Well, Bob Mueller did know then what we know now. And the truth of the matter is they would have never been appointed as a special counsel. There would have been no Bob Mueller. Or if there was a Bob Mueller, it should have been a 2-month investigation and concluded. That's I've said that before. Bob Mueller was in charge of this. All happened under Bob Mueller's watch. He's ultimately the one responsible for all of these irregularities. It happened under his watch.
Okay, so let me ask you this. So this judge appoints a retired judge. He says, give me a friend of the court brief to tell me if I can do this. What does DOJ do, or what are their options, depending on what the court, what this retired judge says?
So Judge Sullivan issues this order, which is like unprecedented. As you said, no one's done it. Now, the Department of Justice has to decide how do they proceed. Well, there's a question of a possibility here that you could go what's called a writ of mandamus up to the D.C. Court of Appeals, the Circuit Court of Appeals, to say, hey, this judge is operating way outside of his constitutional scope and the rules of practice of federal judges in criminal cases, and get a writ of mandamus. So that may be one option. You could maybe even do it's really not a technical appealable order in that sense because there's been no particular ruling yet. But the irony of ironies of all of this is, and you just said it, Sean, was none of this should have happened in the first place. That's the real tragedy here, that General Flynn went through all of this, and none of it should have happened.
Well, not only that, but as you pointed out, you wouldn't have had a Mueller investigation because you wouldn't have had all the predicate in the first place. Let me ask you this real quickly. Knowing what you know now, not just with the Flynn case, but all of these documents that have come out from the Office of National Intelligence, are you concerned that there's more? That it goes a lot deeper?
I'm assuming there's a lot more, and I think that's what John Durham in the investigation he's doing, appointed by the Attorney General to get to the bottom of this whole thing, is going to let the world know what happened there. I think this fraud from the beginning is about to be exposed, and that's why you've got Brennan and Clapper and these others making the statements they are. My goodness, we found out today that Vice President Biden signed an unmasking order request on General Flynn about 8 days before he was no longer vice president.
That's right. All right, Jay, thank you for breaking this all down. It's such an important matter, and only someone like you can really get to the bottom of it in a way that we can understand. So thank you.
Thank you, Sean.